In 1952, Gillett, then 12 years old, met Holt, who was a farmer at the line. The two later became friends and Gillett helped out on Holt's farm. Gillett dropped out of school at 15 and worked full-time for Holt for 40 years, during which Holt gave Gillett and his wife assurances on inheriting his farming business on 7 occasions. In 1974, Gillett was appointed by Holt to executor of his will, with papers appearing to indicate the assurances, but Gillett was not allowed to read them. Holt also refused to give Gillett something in writing to confirm the testamentary dispositions when Gillett asked for it. Still, the Gillets decided that Holt was a man of his words and accepted his assurances. Holt kept on reassuring Gillett that his family has a very secure future and told Gillett that if anything went wrong with his medical operations, the farming business will be all his. However, in 1992, the relationship between Holt and the Gillets deteriorated. Instead, Wood and Holt has developed a very close relationship, and in 1994, Gillet's principal beneficiary status was replaced by Wood under Holt's will, of which Wood also became an executor replacement for Gillett. In November 1985, the legacy to the Gillets and the provisions for them to stay in the beaches had disappeared.
In the Court of Chancery, Justice Carnwath rejected Mr. Gillet's claims. He started off by reiterating the 3 elements in establishing proprietary estoppel. He then proceeded by following Taylor and Dickens and based his rulings on the inherent revocability of assurances. Thus, the assurances were of no legal effect. Further, in terms of detrimental reliance, despite the detriments claimed, Justice Carnwath held that the Gillets did enjoy certain benefits from Holt, thus not amounting to detrimental reliance. In the Court of Appeal, Justice Walker emphasized the need to look at the matter of establishing proprietary estoppel as a whole. The 3 elements stated above should never be analyzed in isolation. To illustrate, the quality of assurances may affect the issue of reliance, while reliance and detriments are often intertwined. Meanwhile, equity permeates all of the 3 elements in order to prevent unconscionable repudiation of assurances. Justice Walker also held that the inherent revocability of assurances is irrelevant to examining the existence of assurance of testamentary benefits. Given that the 7 assurances were repeated over long periods of time, and the representations were mostly made at special family occasions, Justice Walker held that the assurances were meant to be relied on, and the detrimental nature of such reliance will form the conscionable basis of its irrevocability. Justice Walker ruled that detriment need not be equated with mere monetary expenditure or other quantifiable finances. It is sufficient to constitute a detriment so long as there is something substantial. In the present case, the Gillets devoted the best years of their lives serving Mr. Holt and his company with loyalty and devotion upon clear and repeated assurances. This was held to have entailed a substantial detriment, rendering it unconscionable for Holt to backtrack on his promises.
Before Gillett and Holt, if the taxators did not render the assurance an irrevocable one, P.E. cannot be relied on for claiming testamentary promises in case the promisor backtracks his promise, as was the ruling in Taylor and Dickens, which was very controversial and it restricted the applicability of P.E. for testamentary contexts. However, the current approach adopted in Gillett and Holt has departed from the unduly narrow approach in Taylor and Dickens, in which the inherent revocability of testamentary promises was irrelevant to a promise or assurance to leave one's property to another. It is sufficient if the promise is detrimentally relied on. Meanwhile, the detriment need not consist of expenditure of money or other quantifiable financial detriments. It is sufficient so as long as it's something substantial.